Hello, everybody, and welcome to what Florida estate planning and probate attorneys need to know about charging liens. My name is John P.L.L.C, and for the next hour, I'll be giving a live webinar about charging liens in Florida, or what some people might call everything you needed to know about charging liens in Florida, but we're afraid to ask. So we're going to be speaking about some of the appellate court cases, and some of the work that's done on the trial level. We're going to be speaking about a number of ethical issues in the context of charging liens. And you know, our firm is a probate litigation firm, so most of our webinars and CLEs are directed to probate lawyers and estate planning lawyers because we interact with them most. But this webinar is actually appropriate for any Florida attorney who wants to get paid for the services that they render. So for the next hour, we're going to talk about Florida charging liens, and this is eligible for one general credit hour, and it'll be eligible for one ethics credit hour from the Florida bar. So if you're a Florida lawyer, you will be eligible for one ethics credit hour and one credit hour for general CLE. So with that said, this webinar is brought to you by P.L.C. Hauser. P.L.C. Hauser, we're moving into our new office at 415 South Olive Avenue in downtown West Palm Beach. We restrict our practice to trials, disputes, and appeals involving probate litigation and matters involving wills, trusts, and estates, and guardianships and related commercial and business litigation matters. We don't prepare wills or trusts, we only litigate them. I'll invite you to attend our other webinars that we have. For example, in December of 2016, we offered over 3.5 credit hours, ethics credit hours. So if you need Florida ethics credits, you could contact Amanda at extension 101 at the P.L.C. Hauser Law Firm. 561 is the area code, 514-0900, extension 101. Amanda will give you a link that will take you to the CLEs and the ethics credits and show you where you can listen to and also see a presentation, a visual presentation to get ethics credits. 3.5 hours is 2 separate webinars. We also have a number of upcoming webinars that will be Florida Bar approved for ethics credits, and we invite you to check our website, phflorida.com, or contact Amanda at phflorida.com to find out when those webinars are. So with that said, let's talk a little bit about why we're here today and what we're going to try to do. We hope to lend you perspective, right? My law partner, Rob Hauser, and I are litigators, and Rob, in his case, is board certified in appellate law. And throughout our practice with our associates, we see a number of best practices or practices that could be better, and we hope to share them with you today. So these are observations of litigators and appellate lawyers, and we certainly want to try to share with you some of the things that we see out there that you can improve on, and some of the things that are good or that seem to be working. And so we're going to be talking about charging liens today. Charging liens are one of those topics that seem to be misunderstood. The phrase is thrown out there all the time. It's not always accurate, but we're going to be talking about ethics today. We're going to talk about very specific rules of the Florida Bar that regulate our conduct. And we're going to be talking about the tension, the legal tension between getting paid and our obligations and duties to our clients as Florida lawyers. Right? We should be compensated for our time and the services that we provide, but we've got to do it correctly, right? We need to do it right. And our conduct is highly, highly regulated, and so we want to make sure that we're doing it right. So we're going to talk about charging liens today. We're going to talk a little bit about retaining liens. We're going to talk about why we're here today. I'm going to give you a list of appellate court cases at the end. And if you read those appellate court cases, you'll probably know 99% of everything you need to know about charging liens in Florida. So with that said, let's get beyond the discussion outline and talk about our introduction and why we're here today. And I'll give you 56 trillion reasons why we're here today, and 56 trillion reasons why Florida probate lawyers and estate planning attorneys should know about the ethical rules that we're talking about and understand charging liens as well, because you ought to get paid for the work that you do, but you have to do it correctly. Where does the $56 trillion figure come from? Well, the Boston College Center of Wealth and Philanthropy estimates that $56 trillion will be passed from the World War II generation to other generations, subsequent generations, like the baby boomers, like Generation X and Gen Y and the millennials. This is the largest transfer of wealth in humankind, and it's going on right now, and it's expected to be going on for the next couple of decades. And it seems everyone's fighting over that, right? They're fighting over inheritances and will contests and trusts. Everyone uses a revocable trust now to hold their wealth and administer their wealth during their life and when they're gone. And of course, kids and spouses, including second and third spouses, aren't waiting till somebody dies to fight about family money, right? That used to be the old way of doing business, but now with guardianship litigation exploding, contested guardianships are very common, particularly among second and third spouses and children from a prior relationship. So it seems that everyone's arguing and fighting over money, family money, inheritances, wills, and trusts, and they're all lawyering up to do it. So within this backdrop, let's talk about being compensated as lawyers and understanding charging liens. And let's start with our legal duties and our obligations to our clients, right? Rule 4-1.1 requires us to be competent. That means we're not supposed to accept something, an assignment, a task, legal representation, unless we know what we're doing or we can very quickly acquire the necessary and adequate skills to properly represent a client. Rule 4-1.3 is a rule of diligence. It means we can't sit on our duff all day, and we don't have to necessarily do everything with immediacy or immediately, but we've got to do things with reasonable diligence and promptness in representing a client, okay? And so if you attended one of my Florida bar-approved continuing legal education webinars on ethics, like in December of 2016, you heard me talking about the line of cases where somebody goes into an estate planning lawyer's office in Florida and says, I want to change my will or my trust, and I want to, add somebody in or increase a devise to a beneficiary, and the lawyer says, okay, and the lawyer just doesn't get around fast enough to drafting that will or that trust or that codicil or amendment, and the client dies. And so that person who was an intended or maybe not an intended beneficiary of those services is not inserted in the will of the trust. They're not a devotee. And so we talked a lot about those estate planning malpractice cases where the client doesn't live long enough to sign the new will of the new trust. Those are cases involving diligence, right? And we reviewed those cases from the standpoint of, was there privity or no privity, and the changing law in estate planning malpractice in Florida that seems to be broadening or looking at the scope of the services to be provided, and providing the intended beneficiaries with a cause of action for malpractice, although less so in the will drafting fact pattern. And there were cases about deeds and other partnerships and whatnot, where the law seems to be expanding. And I comment that I thought that our diligence requirement, I thought our law was going to expand on that. And so that was one of the diligence issues that we also discussed in that ethics seminar. Rule 4-1.4, communication. We have a duty to communicate with our clients, and that's important, right? And what's our duty to communicate? Well, Rule 4-1.5E actually talks about a duty to communicate the basis or the rate of the fee or cost to the clients, right? The client has to understand what they're paying you. So if it's a contingency, you sure as heck better comply with our rules governing contingency fees. And if you're getting an hourly rate, you should spell out the rates, and you should have a legal, you should have a written legal services contract. It floors me how many of you probate lawyers and estate lawyers out there don't have legal services contracts. At our firm, P.L.L.C. Hauser, we do our best to have a legal services contract with every client. We invite them to have anyone review the legal services contract that they'd like. And we actually put that in our contract. We say it's desirable that you have your own independent attorney review this contract before signing it. And attached to our 2-page contract are terms of engagement, the terms by which we're, the terms of our attorney-client relationship. And we tell them, don't sign this unless you understand it. And you can get your own independent legal advice. Oh, and by the way, there's also a charging lien in our legal services contract. So here's another rule, 4-1.6, regarding confidentiality, that, politely, most of you probate lawyers just don't understand. We have a rule about confidentiality, right? We're not supposed to share client stuff with other people, right? We're not supposed to tell other people about our client and their stuff. And so where I see that in the probate or the estate context is probate lawyers are often giving client information to non-clients. Like you have a spouse as a client, and the kids call up, the adult kids, and they say, give me a copy of my mom or dad's estate planning file, and you folks do that. And the kids are non-clients, and the client didn't give you written authorization to do that. Well, you're not supposed to do that. That's wrong. You also have to be mindful of spouses and marriages, right? If you're, particularly in Florida, right, we see a lot of second and third marriages. So if your client is one spouse, and the other spouse calls up and says, let me ask you about Melvin's will or Agnes's revocable trust, you shouldn't be speaking to them about that, right? Unless you have written authorization from your client to share it with someone. Another issue about confidentiality, or more so the attorney-client privilege, is when a client wants you to talk to her and her son or him and his daughter, right? When you put that non-client on the phone, now you have a non-client as a part of a communication and a conversation, and conceivably that's all discoverable by the other side. So be careful about breaking that attorney-client privilege by permitting family members or loved ones who don't have a joint defense agreement or a similar stake in the outcome of any matter on the line with you. Conflict of interest with current clients, right? We can't take adverse positions to former clients, let alone existing clients, right? And Rule 4-1.16 talks about terminating representation, when a lawyer must decline or terminate representation. And one of those is when a lawyer is discharged, right? When you're fired, you've got to take steps to still protect your client, right? That's subsection D there, protection of client's interests. So when you're fired, it doesn't mean you don't do nothing, right? It doesn't mean you just sit back. You still have a duty to protect the client. When we're fired or when we withdraw, we put that in writing to a client. We say, look, you should begin to look for another lawyer immediately. And please sign this consent to our withdrawal. And you don't have to sign the consent, but understand there'll have to be a hearing if you don't consent. So let's work through this. Let's get through this. And we typically try not to bill although we track our time entries contemporaneously with the services we provide. We try to track our time entries, but not charge for them generally after we're discharged or we withdraw. And I'll tell you, if you've ever been in a fee dispute or a fee hearing or a fee fight, judges are receptive to that. They like the fact that you're not charging after you've been discharged or you're withdrawn, because there is work to do. You've got to draft either a substitution of counsel if the other side doesn't do it, or a motion to withdraw and a consent. You might need a hearing and blah, blah, blah. There is a little bit of time that's needed. But, you know, if you're discharged, that's important from a charging lien perspective, right? Because the question then becomes, particularly on a contingency fee case, whether you get quantum merit, you know, the number of hours times your hourly rate or a reasonable hourly rate, or whether you get your contingency fee, you know. And so we can all imagine cases where you're on the eve of settling a matter, or maybe you've got a verdict or a judgment, and then the client fires you, and now you're out your contingency fee. Well, there's cases out there and there's rules out there that say clients can't do that. But you know, if you look at Rule 4-1.16, terminating representation, subparagraph B talks about when withdrawal is allowed. And so one of the subsections is, you know, if you find something to be repugnant, imprudent, or you have a fundamental disagreement with the client, you can withdraw. And that's an important distinction, right? Some clients are under the misapprehension that you as a lawyer have to do whatever they say. And that's just not the case, right? And that makes sense, right? Because if a client asks you to do something frivolous or criminal, we wouldn't do that. And so a client doesn't have carte blanche. Now, you have to protect your client. You have to look out for them. But you don't have to do things that you have a fundamental disagreement with, or something that you find repugnant or imprudent. And so be mindful of that, right? Because we all, particularly in the estate context or the probate litigation context, trust lawsuits, right, and even guardianship lawsuits, where a family member is so emotional, they want to do stuff that you find either distasteful or baseless or improper or imprudent. And you should tell them that. In my judgment, that's not appropriate. And you should say, no, I'm not going to do that. I mean, many times you'll see clients who lose a hearing who want to disqualify the judge for no reason other than they lost a hearing. Totally inappropriate, right? You know, that's not your solution, is to get rid of the judge. You can't judge shop around here, and that certainly there's no basis to have a judge removed. So be mindful of that, of what clients are asking you to do and whether you should be doing those things or not. Now, as far as getting paid goes, take a look at paragraph B, as in boy, subsection 3, right? Withdrawal is allowed if a client fails substantially to fulfill an obligation to the lawyer regarding the lawyer's services, right? Like, you agreed to pay me and you haven't paid me, or we've got a trial coming up, or we've got a whole mess of discovery coming up, we've got a whole mess of hearings coming up. Please provide a deposit, which I'll put into my trust account for your benefit. And if you had a legal services contract with the client that said that additional deposits may be required, and you ask them for that, and they don't do that, you know, you have the ability to withdraw, providing you've given a reasonable warning to the other side, and you've said, hey, you know, I need an additional deposit. Those were the terms that we agreed to, and I'm providing a polite warning to you. Right? Unless that obligation is fulfilled, I'm going to withdraw. Why? Because that's not the deal we had. Those aren't the terms of representation that I agreed to and my firm agreed to. So that particular rule regarding terminating representation is a very important one. A lot of important issues within that one. Let's turn to the rules regulating the Florida bar. We know that we have 4-1.5, fees and costs for legal services. Any probate lawyer probably knows that by heart, right? Particularly if you've had anyone object to your fees and costs. You know that a hearing is required. You know that appellate courts have said consistently that you need an expert to render an expert opinion about the reasonableness of the fees, right? But 4-1.5 recognizes the tension between being compensated and the duties you owe to your client, right? So if you look at 4-1.5, you'll see that certain fees are clearly prohibited, like excessive fees, right? And that's sub A. And then sub B goes into all the factors to be considered in determining a reasonable fee. And so your expert and you as well in a fee fight or a fee hearing will provide testimony about the factors in Rule 4-1.5B, the factors to be considered in determining reasonable fees. And why is that important for charging liens? Well, if you get discharged, if you're fired or you quit, and you have a charging lien, you might have a disagreement over entitlement and amount, right? And so what's reasonable is going to come down to a judge many times. And so it may or may not be all the hours that you spent working on a case, and it may not be the hourly rate that you want, right? So while we're talking about reasonable fees, how many of you out there have a provision in your legal services contract that limits the time for a client to review an invoice? There was an appellate court decision that I should have cited in this materials that said 30 days was fine. And I know more and more firms are doing that. They're saying, look, we're going to send invoices to you by email only, and you agree to review them carefully within 30 days and to raise any objections or disputes within 30 days. And you also agree that if you don't raise objections to our latest invoices within 30 days, that you accept them. Another consideration for your legal services contract, subparagraph D as in dog talks about the enforceability of fee contracts. E is that duty to communicate the basis or the rate of fees to the client, and gives us some definitions. More specifically, the difference between a retainer and a flat fee and an advance fee, which some people call an initial fee. If you're getting an advance fee or an initial fee, you should put in your legal services contract whether it's refundable or not. And if it's not refundable, we know that's got to be in writing, signed by the client, and it should say it's a fee earned. And if it is refundable, you should put language in there that says, to the extent it's not used or earned, that advance fee or that initial fee is fully refundable. And how many of you have language in your legal services contract that talks about the authority to use funds on deposit, advance fees, or initial fees to pay your invoice as services are rendered and invoices are sent to you? You should consider having that language in there as well. One last note on rules regulating the Florida bar and fees is that you cannot split fees with non-lawyers, right? So some lawyers pay a referral fee to a referring attorney, and there's separate rules for that. The referring attorney has to be available for consultation, and the client has to consent to it in writing and all that good rut. But you can't split a fee with a non-Florida lawyer, right? So we know you can't split a fee or share a fee, pay a referral fee to a non-lawyer, all right? So we know there's lots of cases out there that you can't pay your paralegal a referral fee, and you can't disguise it as a bonus. That's improper. And we know you can't pay any other non-lawyer a referral fee, but where sometimes it's misunderstood is a lawyer in another state who is not admitted to practice in Florida is a non-lawyer. In the eyes of the Florida bar, you cannot share a referral fee and any type of fee with a lawyer from another state who's not admitted to practice in Florida. Okay, 5 things you need to know about charging liens. Number 1, elements of a charging lien. What's a valid charging lien? Well, you can see the Walther case there. It's a 5th District case from 2013. And generally, there's 4 requirements for a valid charging lien. And most people would tell you the most important is the 4th one, right? The one that's in bold at the bottom of your screen, timely notice. You've got to give notice regarding a charging lien. And so you're probably saying to yourself, well, who do I give notice to? And the short answer is sometimes everybody, right? So you should consider having charging lien language in your legal services contract, and you should consider inserting language that says, look, you client grant firm authority to give notice of our charging lien to anyone in any court, or to file it in any public or private form, including public records or recorded records, right? You want to be able to give notice of that. Typically, notice should be given to the client. Hey, I have a charging lien, and it's in this amount. But in the case of probate litigation or estate litigation, you probably should be giving notice to the personal representative or the trustee of the trust, or maybe the guardian or the guardian's lawyer, if you're seeking fees and costs from a ward or a ward's bank account or something like that. So you've got to give notice, and you probably need to give it to the person who's got the purse strings. But there's generally 4 elements of a valid charging lien. You need an express or implied contract between an attorney and a client. And we like written legal services contracts. And our legal services contracts typically say, in our 2-page contract with terms of agreement that are attached, please understand that firm does not begin work until we receive a signed copy of this contract and the initial fee or the advance fee. And in our legal services contract, we specifically insert language that says a copied, scanned PDF or electronic version of this is considered an original. You also need an express or implied understanding for payment of attorney's fees out of the recovery. It's amazing what convenient amnesia clients get if something is not in writing. So you should have a legal services contract that's signed by you, signed by the client, that says how you're going to be paid and under what circumstances, right? Because if things go south and the relationship deteriorates, it's amazing how much clients or former clients forget. Then you need either an avoidance of payment or a dispute as to the amount of fees, as well as notice. So generally, those are the elements of a valid charging lien. So understand it's not enough just to provide services, right? The fact that you provided services isn't enough. It's not like poof, you all of a sudden have this lien. You've got to give timely notice, and you need a contract, and it needs to be clear that you were that person's lawyer. And then the second bullet point on this slide, your services must produce a positive result or settlement. That seems to be more appropriate in the contingency cases, right? So when you read these charging lien cases and you study these concepts on charging liens, you recognize that there's different categories and some recurring themes. The contingency case, where maybe somebody took a PI case on a contingency and they're discharged, right, or they're fired, and they have a charging lien, that's kind of one set of facts. For you probate and estate planning lawyers in Florida out there, you're generally not doing that. Many of you do flat fees, right? And some of you don't get paid in advance. I get that. And so then if you've provided services and you've produced an estate plan, or you've reviewed documents or something, those are positive results. There's no settlement, but you've done work for the client, right? That's another set of facts or another category. And so you have to understand those types of categories and those sort of essential requirements. And so the Walther case that's cited there, and it cites the Correa versus Christensen case, a fifth DCA case from 2001. Generally, the lien attaches only to the tangible fruits of the services provided by the Florida lawyer. And that's generally in the context of contingency cases, right? You know, people fight over contingency fees. You know, you hire one PI lawyer and they get you an offer, and maybe you reject it and you fire them, or they quit. And if they quit, that's a different story because they're not getting paid. But maybe you discharge them and they claim they have a charging lien, and then you go to firm B or C or D and they resolve the case, and there's an argument about how are those fees to be split between the first law firm that has a charging lien and the new law firm that you know, got the check in their trust account, right? And so your lien attaches generally to the fruits of your labor. You should state a basis for your charging lien. Like, you gave me a charging lien, or the client gave me a charging lien in writing in our legal services contract. And you should, according to the Walther case, your notice should allege that your services produced monies or other tangible property or a positive result. So if you read the Walther case, the bullet points that you're seeing on the screen in front of you are from allegations made in one of the court file documents, right? So there's a difference between, you know, telling the client you have a lien, telling the trustee you have a lien. Don't distribute money to my client beneficiary or former client beneficiary because I have a charging lien. We'll get into a discussion of spendthrift trusts and spendthrift provisions another time. Or you give notice to the personal representative of the estate. Don't distribute money to my former client, yet I have a charging lien. And there's cases out there that say, look, charging liens are supposed to be resolved prior to the settling or resolving of any case in the passing out of monies, right? Distribution of monies. So in the Walther case, there were court file documents, and you can do that, right? If there's a court file document, a court case that's open, like a probate or a trust lawsuit or a guardianship matter, you should file your lien in that particular proceeding. You know, that's one of the best ways to try to enforce your rights to payment. So how do you provide timely notice? Sure, you can use email. You can file a notice in the pending manner, and you can certainly communicate it to client's new counsel. And there's a Florida Supreme Court case from 1986 that you can review. But the clock is ticking, right? We don't want to wait. You want to get your lien filed and communicated and give notice as fast as you can, right? No one likes lawyers kind of sitting back and coming in at the last minute and upsetting the apple cart. And you still need personal jurisdiction over the attorneys, right? So for some of you probate lawyers or estate planning lawyers out there in Florida, many times you'll get a non-Florida client. Maybe somebody's from Connecticut or New York or Massachusetts, and they call up and they say, hey, we're going to buy a house in Florida, or we've been renting and we're ready to buy, or we own a house in Florida already, but we're ready to become Florida full-time residents or domiciles. We want to get a new estate plan, and we were told it should all be Florida documents. We want to hire you. And you say, that's great. So what happens if you perform a few services for these nice people from Connecticut or New York or Massachusetts and they don't pay you? Do you have to go to Connecticut or Massachusetts to sue them to get paid? Well, most lawyers would tell you if you own real estate in Florida, that can subject them to personal jurisdiction in Florida. Well, that's true. That's right. I think the better way to address that is to have a mandatory forum selection clause in your legal services contract that says, for any matter between you and the firm, including fee disputes, including any actions by you against firm, we agree here and now that those matters will only be resolved in a Florida court, right? And you can read all about these mandatory forum selection clauses versus a permissible forum selection clause. But we put that right in our legal services contract, and we even say this is a mandatory forum selection clause. Because sometimes it's forum selection clauses that are poorly drafted that are not obligatory and mandatory, they're permissive. You know, like the parties may seek redress in a Florida court. Well, that doesn't require you to do that necessarily. And the last thing a Florida probate lawyer or a state lawyer wants to do is have to go get paid in Connecticut or go out of state or go to Massachusetts or something. So consider a mandatory forum selection clause in your legal services contract. But you know, in this case, in the Jaffe case, that's a second DCA case from 2010. There was a non-Florida lawyer who was discharged, and the issue came up: can that non-Florida lawyer get paid? And can you resolve that in the Florida matter, or do you have to resolve it in the location or the state where the non-Florida lawyer is? So you had a former client who had filed a products liability action against the defendant in Polk County with new counsel, right? After a non-Florida lawyer was discharged. And then you had that client initiate a proceeding by filing a complaint against the former lawyer, the former law firm, who were non-Florida lawyers, right? I think they were from Pennsylvania. And they said, we want to determine our charging lien. We got notice from these non-Florida lawyers that there's a charging lien. So what did they do? The client, you know, files this action in Florida and says, hey, determine this charging lien. And the second DCA said, you forgot one thing. You need personal jurisdiction over your non-Florida lawyers, and I don't see that you have it. So you got to be mindful of that. The second thing you may want to know about charging liens of Florida, and on the screen you see a picture of a photograph of my law partner Robert Hauser appearing in front of Florida Supreme Court just a few months ago in 2016. You want to consider the appellate review, right? And you can look to the Walther case again for a little information on that. The trial court's order on charging liens may not depart from the essential requirements of law. If they do, you can seek cert from your district court of appeal. Okay, so an error at the trial level regarding charging liens means that cert relief is required to prevent material injury that cannot be corrected on a post-judgment appeal. That's powerful language, and as you'll see, not surprisingly, right, is that the charging lien is one of the strongest liens that exists in the law, right? The lawyer's charging lien, consistently given lots of strength and emphasis by our appellate courts. And so if the trial judge makes a boo-boo about the charging lien, you know, if you have some hearing on it or something, what our courts have said is, God, you know, you have to go to the district court because, you know, that's material injury that can't be corrected on a post-judgment appeal. So what's your takeaway from this? If you have any hearings on charging liens, one, have a court reporter to accurately take down what's said, right? So you have a record, because if you don't have a record at the district court of appeal, the trial court's most probably going to be affirmed, right? Because the appellate court can't tell you whether what they did was right or wrong, maybe not. But two, prepare for an appeal, right? If you have a bad day, consider the possible appellate issues or seeking cert relief prior to that hearing. So if things go south at your charging lien hearing, you can seek the appropriate relief at your district court of appeal. Number three, where do I go? Wait a minute, if I've got a charging lien, what's the proper forum? And for that, you can read a more recent, a 2015 third DCA case, CK Regalia. The proper forum generally is the present court, the present division the pending action. That's generally the proper forum for you to adjudicate your charging lien is wherever you were for your client, right? If you were in the probate division in Palm Beach County, that's where you're going. If you were in the civil division or the trial division in Broward or Dade County, you're going in front of that judge. So the proper form for adjudicating the validity, enforcement, and amount of a charging lien is with the trial judge before whom the underlying action is pending. Well, what if you're an estate lawyer and you provided services and there is no pending action? Maybe you drafted documents or reviewed documents, or you did some corporate work and you created a family limited partnership and you transferred or some interest in the LLP or the LLC, or you sold an interest in it for a note and did all this great work, and you didn't get an advance fee or an initial fee, and your client's not paying you. Well, you give notice to the proper people, including the client. You may or may not be able to give notice to the partnership or the LLC or those entities that you helped create. But then you've got a collection action, right? And if it's more than 15 grand, you go to the civil division. If it's less than that, you go to the county division, and now you're off to the races. So a separate deck action, right, to have a charging lien declared or determined to be valid is invalid, or can be invalid, and an improper advisory opinion. And what that means is, if you have a pending action, like let's say you're in the probate division of Martin County because you were providing services to an estate or a trust up there, and maybe you're discharged and you assert a charging lien, and your office is in West Palm Beach, Florida, where your probate litigation practice is most probably improper to file a deck action in Palm Beach County to have your charging lien declared or determined to be invalid or valid or proper or invalid, improper or proper, right? That's generally, you're in the wrong forum. You need to go up to Martin County in our example. But in the contingency context or in the trial context where you don't have a recovery yet, that's putting the cart before the horse, right? So if you get discharged before the judgment comes down or the settlement occurs or damages are assessed, you don't have a contingency. There's no money there from which onto which there's no fruits of your labor necessarily to assert your charging lien in one sense. So be mindful of that. What forum are you in? Are you in front of the proper court? And if your contingency hasn't happened yet, you can't file some deck action where your practice is. That's going to be viewed as an invalid and improper advisory opinion. So the lesson is to be patient, right? So in a contingency fee matter where counsel is no longer employed, determining the validity of a charging lien is premature until there is a recovery. Okay, so you can get to court. Just be mindful of which court you're getting to. Okay, what's the difference between a retaining lien and a charging lien? And is a retaining lien really something that's archaic and going away? Probably. So an attorney has a right to a retaining lien upon all the client's property in the attorney's possession. The lien may not be impaired by clients securing the right to inspect and copy or compelling their production that would render the lien meaningless. Wow, that's powerful language. When you provide legal services in your legal services contract, you should consider incorporating language that has the client recognize that you're protected for non-payment by two forms of lien in the state of Florida. One's a retaining lien that gives you a right to retain the file and one's a charging lien, and they're different, and you should understand them, right? So what's the difference between a retaining lien and a charging lien in Florida? Well, you're generally talking about a charging lien covers the balance due regardless of whether the property is related to the matter or not, and the lien may be enforced until payment or a pressing need for the property. So a retaining lien says, I've got a lien on the file. I've got a lien on the property that I'm holding in my law firm related to your matter, right? And so it covers the balance due, right? You owe me X, maybe you paid me Y, but there's a balance due, and I want to enforce my lien. And so, and you see the Conde and Cohen case there, and the other cases on retaining liens. You don't want to give up the file, right? The client fires you, and then they say, "Hey, send the file over," and you say, "Nope, don't have to do that. I've got a retaining lien." And then so what happens? The new lawyer comes in and says, "Judge, motion to compel. I want to go in and inspect those documents, or I want to copy them." And what our courts have said is, no, that's an improper end run around the retaining lien. The retaining lien was created for lawyers so they don't get stiffed on their fees. All right, you have a right to keep the file. And if you go in and copy the file or you look at it, right, that lien is really useless, right? Because you just got what the lawyer was securing or holding in hopes of getting payment, right? Now, there is a carve-out. There is an exception for some type of pressing need for the property. You've got to demonstrate that, and that probably should be done through evidence, not oral argument by a lawyer, because oral argument is never evidence. And a judge should probably make very specific findings of fact about the pressing need, and you should have witnesses to call, and you should have rebuttal witnesses if you're trying to, if you're involved on the other side to determine or to try to demonstrate there is no pressing need. And adequate security for payment has to be posted. That's another requirement. So you can look at that Fox case. It's a 2013 third DCA case. I'll give you a little bit more. Okay, so let's start winding down our seminar now, and let's try to get through the last few topics as we end or begin to end this webinar on Florida charging liens, sponsored by P.L.L.C. Hauser. Getting paid, so you've really got to know what type of charging lien you have, and what I mean by that is, was it a contingency case? Was it an hourly case? Was it a flat fee? What were the terms of the representation? Did you have a legal services contract? What did it say? You know, if it's a contingency case, was there a contingency? You know, was there a settlement or a verdict? Is there money out there to satisfy the lien right now? You know, has that contingency occurred? Otherwise, it might be premature to discuss a charging lien. You know, how were you to be compensated? And was co-counsel involved in the case, right? And there's all these lines of cases where, you know, courts want lawyers, including multiple law firms, to share the contingency fee or to share fees, even for discharged lawyers, maybe on a quantum merit basis, but the courts are reluctant to pay more than one lawyer or sets of lawyers. So if you're involved in a contingency case and you were discharged, know that you're probably going to have to split fees with the other lawyer if a contingency was achieved. And you darn well better know whether you were discharged, i.e. fired, or whether you withdrew, because if you withdrew, you're on a contingency case, you're most probably not getting paid. Not necessarily the case with an hourly. We're going to give you a bonus here. We only promised 5 things you need to know about charging liens. We're going to give you a 6th at no charge to start the new year off right. You can call this the ethics of a charging lien. And the question I'm going to leave you with is, What can you get a charging lien over, right? And your legal services contract should say, you're giving us a charging lien over, and then you fill in the blank, okay? Can you get a charging lien over homestead? Now, you probate and estate lawyers out there, many times you're dealing with homestead, right? And so can you get a charging lien on someone's inheritance? Sure. Can you get a charging lien on someone's inheritance from a trust? Most probably. We've got to discuss spendthrift provisions, right? And whatnot, and we'll talk about priority of liens in a moment. But can you get a charging lien over homestead? Be very, very cautious. Read the James v. DeMaio case. It's a Florida Supreme Court case for an analysis on whether a client can waive their right to homestead or their homestead protection. You can read the bankruptcy case from 2014, In Re Fury, F-U-R-E-Y. Yes, clients can waive their homestead protection in your favor, but you have to do it properly. A legal services contract that's signed is not the proper way to have someone waive their homestead protection or their homestead rights in favor of you or your law firm. You can also read a little more recent case from Florida's Second District Court of Appeal in 2014, the P.L.L.C case, F-E-L-I-C-E, the citation's there. Generally, you need some type of a mortgage, or you need some type of voluntary waiver with two witnesses and a notary, right? So if you're looking for a charging lien, or if you're looking to get paid from the sale of someone's homestead, including a beneficiary such as an intestate heir or someone who inherits the homestead, right? You don't want to sign them up on a Monday, get their homestead for them on a Tuesday, or maybe a deceased person's homestead on a Tuesday, and on a Wednesday, they say, I'm not going to pay you your legal services from the sale of the homestead. I read this article and it's protected and the sale proceeds are protected and blah, blah, blah. And you say, well, you gave me a charging lien in the legal services contract, and the Florida Supreme Court has said that's not enough. You need a voluntary relinquishment of homestead protection rights, and you need two witnesses, and you should have a notary. Or else you'll end up at court arguing about that. So here's the case law that you can look at, and I just want to bring your attention to two things. There's a case that was not mentioned there. It's from August 18th, 2016, the Salzman case, S-A-L-Z-M-A-N v. Reyes, R-E-Y-E-S, 198 Southern 3rd, 1068. 198 Southern 3rd, 1068. It is a First District Court of Appeal case, and that is a more recent charging lien case that stands for the proposition, among other things, that Florida has adopted the modified quantum merit rule, which limits recovery to the maximum amount of the contract fee in all premature discharge cases involving both fixed and contingency employment contracts. It also discusses what's a stipulation and the effect of a stipulation, but you can read the Salzman case if that's helpful. And then there's the Link case, right? The Christopher Link, which is number 7 on the slide in front of you, and that's priority of liens. Whose lien is superior, and is a charging lien superior to a judgment, right? You have a client, the client fires you, you file a charging lien, right? And then the client gets all this money, right? And there's somebody, maybe there's an attorney's fee order that's entered against your client. So your client has to pay you, and maybe your client has to pay the other side, but your client's going to get some money. And then the question becomes, who gets paid first, you or the person to whom the client owes the attorney's fees by the order, right? That's an interesting case or fact pattern to consider, right? So in the Link case, it was a divorce, a family law case. It's a priority of lien case, right? and there was a former husband who had a lien over the former wife, right? And so the courts got into a consideration of, well, when was the judgment actually entered? And when was the date of the legal services contract, right? So who does a losing side pay first, your attorneys or the winning side? Right? If the losing side has to pay fees to the winning side, and the losing side also has to pay her lawyer, who gets paid first? Her lawyer or the winning side? And in this Link case, it was the winning side. You can read the specifics about that. But if you're involved in a case where there might be fee shifting and there's a charging lien, be very, very cautious. There are priorities, even though charging liens are one of the strongest liens in Florida, be mindful there are priority cases there. The Florida Bar course number for this live webinar is 160-9636, N as in Nancy. It's on the slide in front of you. I want to thank everybody for listening and invite you to email or call me, John P.L.L.C, or my law partner, Robert Hauser, board certified in appellate law by the Florida Bar, if we can ever be of any assistance with charging liens, any estate, probate, guardianship, trust, will litigation, as well as related real estate and commercial litigation. We've been handling a number of cases involving real estate, homestead, and partition. I know a lot of people want to shy away from that. We tend to like those cases, and God knows Rob does a fantastic job with all of our appeals. I want to thank you for listening to this live webinar and invite you to check back with P.L.L.C Hauser, phflorida.com, for future webinars, including webinars that qualify for continuing legal education credit from the Florida Bar. You can contact Amanda at phflorida.com or 561-514-0900. Her extension is 101. And I want to thank everybody for listening to our webinar on what Florida lawyers, including Florida probate and estate planning lawyers, need to know about charging liens. This concludes our webinar on charging liens.